Hello, everyone, and welcome to today's family law webinar on divorce basics. We hope everyone is doing well, and we thank you for joining today's discussion. I'd like to introduce our presenters. Susan Lichterman is Jaffe's Family Law Practice Group Coordinator. She has over 30 years of family law experience. She specializes in all aspects of family law, including divorce, custody, parenting time, and support. Susan also does some appellate work. We also have Jennifer Latache. She is an equity partner in Jaffe's Family Law Practice Group. She has over 20 years of experience and similarly specializes in all aspects of family law, including divorce, custody, parenting time, and support. Jen also does some probate litigation work as well. And my name is Christiana Bautel. I joined Jaffe's Family Law Practice Group in 2018. I focus on family law, but I also practice some probate litigation. First, we would like to cover a few housekeeping matters before we get started. Everyone is going to be placed on mute during the session to prevent potential background noise. But if you have any questions or comments, please submit them at any time via the Q&A box below. Time will be allocated at the end of the session to address your questions, but we may also take a few questions during the webinar if they're applicable to the current subject. Our agenda for today covers what does no-fault divorce really mean? The overview of the divorce process in Michigan, answers to commonly asked questions, and then again, an audience Q&A at the end. So first, let's start with a polling question to see where you would like us to focus today's discussion. If you want to answer the question that just appeared on your screen, what are you most interested in learning about during today's discussion? We'll give you a few minutes or seconds to respond. Okay. All right. Looks like most people are excited to hear about the overview of the divorce process in Michigan. All right. So Susan, what does no-fault divorce really mean?
Thank you, Christy, and welcome everyone to our second of our three-part webinar series. And I just like to state that this is meant to be an overview, and it's not one size fits all. And Jen, Christy, and I look forward to hearing from you about any individual and questions you might have. But what does no-fault divorce really mean? It really means what it says, that you can get divorced for no reason or any reason at all. Back in the day, and actually before I started practicing, you had to allege fault in order to get divorced. And I remember a judge, when I first started practicing, saying to me, all that meant was let the perjury begin. Because often folks just want to get divorced. They've fallen out of love, they've had enough, and you really shouldn't have to have a reason to stay married. So Michigan enacted the no-fault divorce statute, and what that means is the complaint, all we have to allege is that the object of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. That's it. We don't have to say that your spouse did something horrible. We don't have to make any specific factual allegations. That being said, that doesn't mean that fault is not considered at all. And in fact, fault can be considered when addressing both property settlement and when addressing spousal support and alimony. Both property support and property settlement and spousal support are based on equitable factors: age of the parties, health of the parties, length of the marriage, contribution to the marital estate. And one factor that the court can consider is fault. But as we like to say, we never want to see you spending more on attorney fees to argue fault. We never want to see you run up a $20,000 attorney fee bill in order to get $10,000 more in property settlement or a few more $100 in alimony. So when we go the fault route, it's something we discuss at length. It's something we consider, and we want to make sure that it is that the cost benefit analysis is there. And in general, the type of fault that we would consider would be dissipation of assets, gambling, if someone was involved, drug, alcohol abuse that really led to a deterioration of the marriage and the marital estate, spousal abuse, domestic violence, and of course, the most common question, my husband, my wife is having an affair. Well, in today's world, in general, and I don't mean to say just an affair, it takes an emotional toll. It's a difficult situation, but an affair alone generally is not going to rise to the level of fault that we would want to litigate over it. The person having the affair likely is going to argue it was a symptom of the breakdown, not the cause of the breakdown, that the marriage had already broken down. That being said, when there is an affair, when there is, as we sometimes say, extracurricular activity, that doesn't mean we're going to ignore it. We're certainly, and especially if the spouse is spending a considerable amount of money on these activities. We've had cases where we've had a boyfriend, a girlfriend on payroll, a second house, an apartment, trips, lavish gifts. Certainly, we're going to look into all of that, and whether we call it fault or not, we're going to look to bring those funds back into the marital estate so that it's all accounted for. But this, of course, is getting the cart before the horse, because the most important is to give you sort of the overview of the divorce process. But we find when our clients come in, the first question always is, what is no-fault divorce? So we lead off with that. But then, and it will come up again and again, likely throughout today's discussion. But now I turn it over to Jen to start the overview.
Actually, Susan, we did get a question.
Oh, sure.
What if I don't want to get divorced?
Well, unfortunately, you don't have a choice. And that is really the essence of no-fault divorce. If your spouse wants a divorce and he or she files for divorce, you can argue about the property division. You can argue certainly about parenting time, custody, things related to your children. You can argue about spousal support, but the fact of the divorce, your spouse is going to get a divorce if he or she wants one.
Thank you, Susan. Next slide. Jen, will you discuss the overview of the divorce process in Michigan?
I would be happy to. So hello, everyone. Thanks for joining us today on our second of three. So once a difficult decision has been made to proceed with the divorce process, the first step in initiating that is to file the complaint for divorce. Now, a lot of people assume that there's a ton of information that needs to be included in that. And while there are the specific requirements on what needs to be included in the judgment, it does not have to be lengthy, and it does not have to provide a significant amount of personal details. So it's a relatively easy document to draft. It really just kicks off the process and notifies the court that they have jurisdiction to hear the matter and to proceed with the divorce process and with finalizing a judgment at the end of the period. So the first thing that you have to include in the complaint for divorce is letting the court know that they have jurisdiction. And that in Michigan says that you have to be a resident of Michigan for at least 180 days before you file the complaint for divorce. And also for the county that you're planning on filing in, you have to be a resident of the county for at least 10 days. So if you meet those two residency requirements, then you can proceed in that particular county. As Susan mentioned, you do not have to tell the court why you're asking for a divorce. You don't have to provide specific details. You simply have to include in the complaint that the objects of matrimony have been destroyed and there's no reasonable likelihood that the marriage can be preserved. That's it. You don't have to talk about affairs. You don't have to talk about falling out of love. You don't have to talk about anything. You can just simply put that sentence in, and that's enough for the court to proceed. Regarding assets and liabilities, again, you do not have to include specifics. Really just let the court know that they exist that you do have assets, if you have real property, and that there's liabilities that have accrued during the marriage that need to be resolved at the end of it. Very simple sentence. If there are minor children involved, there are more specifics that the court requires. We're going to talk a little bit more about parenting time and custody in our third of the series. But for the complaint for divorce, what you need to include is whether or not there are children under the age of 18, their names, their ages, and where they've been living for the last few years. Those are statutory requirements. You don't have to get into specifics and tell the court how you want custody and parenting time to look at the end. If there's a specific reason that you think that sole custody is relevant, then you might put that in there. But you don't have to get into specifics about the parenting time schedule yet. Just ask the court that at the end of it, you want a reasonable parenting time schedule for the parents. And you also have to let the court know if the wife is pregnant. If someone's pregnant, you definitely have to let the court know, because that'll impact moving forward. If there are children, or if somebody is asking for spousal support or child support, we have to fill out what's called a verified statement. That's a little bit more of a detailed form regarding finances. But for the complaint for divorce, those are pretty much all that you have to include regarding the kids. There's some minor things to include, such as your name now, your name before the marriage, the date of your marriage, and things like that, but nothing too complex. Once we get all that information in there, the person who's filing for divorce will review it, make sure it's accurate, and then sign it and swear that they're telling the truth and that everything in there is accurate. And then we'll get it filed in the county that you're looking to proceed in. So once it's filed, the court then issues what's called a summons, and then we will serve the summons and the complaint for divorce on the defendant within the prescribed amount of time, so we can proceed with the divorce case. So that's pretty much all that needs to go in the first step.
Thank you, Jen.
Mhm.
We did get another question. Does it matter if I am plaintiff or defendant?
Not really legally. The only reason that you might consider filing first or being the plaintiff is if you have a need to ask the court right away to enter what we call ex parte orders. Those are orders that the court can enter when they've only really heard from one party and not the other party. Those common ones that we enter for divorce process would be an order for the status quo, to preserve the status quo, and ask the court to require the parties to pay the bills as they've historically paid them in the past. And another one that we might want to enter is a preservation of assets, requiring that neither party can dissipate a marital asset or change beneficiaries on a life insurance or health insurance policies, things like that. So if there's any concern that there might be dissipation or failure to pay bills in the interim, then you might want to file first and proceed there. But legally speaking, there's no difference between the plaintiff or the defendant.
Thank you, Jen.
Mhm.
Susan, will you please the overview of the divorce process in Michigan?
Well, the last question led us right into our next slide about ex parte orders. And as Jen indicated, the most common ex parte means without notice to the other side. And that's asking the court to enter an order, not only without notice, but without a hearing, based just on the pleadings, just on your complaint, or perhaps a motion that you file with the complaint. The most common ex parte order, as Jen indicated, are either for the status quo to keep paying the bills, or what we call a mutual restraining order to prevent either party from dissipating assets. And almost every court in every county in this state will enter these two orders as a matter of course, with very little fact basis for the orders. We generally just put a line in the complaint that I'm fearful, or if my spouse dissipated assets, it would cause irreparable harm to the marital estate. I mean, it doesn't take, it's just sort of common sense that if someone starts moving around assets and dissipating assets, it's going to cause harm. So almost always the court will enter those orders. And occasionally, we need to get more serious relief and such as someone left with the children, someone has done something that we need the court to act on right away. And in that case, for example, if someone took the children and left the state or left the marital home, and you we might do an ex parte order, and then we would need a lot more detail, and we would actually file a motion with the complaint setting forth all the facts, asking the court to act on an expeditious emergency ex parte type basis. So that is what ex parte orders are, and as Jen said, that might be a reason why you would want to be the plaintiff rather than the defendant. Then there are what we call the statutory waiting periods. And in every divorce, the soonest you can get divorced is 61 days after you file the complaint. There is a mandatory 60-day waiting period for every case. With minor children, that statutory waiting period is 6 months. And historically, courts have been willing to waive after the 60 days the balance of the 6 months if the parties have worked everything out and it's not 6 months, but they've settled everything, custody, parenting time, property. Generally, you could go to the court and say, I think it's in the best interest of our children to waive the balance of the 6 months, and almost always the court would do that. I'd say in about the last 5 years or so, in some of the counties, some of the judges are not just doing it as a matter of course, because there's actually a statute that says the court has to find that it's in the best interest of the children to waive the 6 months. So we now have some judges, and again, it's case by case, county by county, that won't just as a matter of course waive that 6 months. But in most cases, it's pretty rare that we're completely done in less than 4 to 6 months when there are kids. And it's just by the time that we get through the assets, get through the financial aspects, and then deal with custody and parenting time, it generally just does take in the 4 to 6 month range. If you are the defendant, the second step after the plaintiff files is answering the complaint. The answer needs to be filed 21 or 28 days after the complaint is served, depending on how the complaint was served. And the answer, like the complaint, is really very simple. A document that basically just says for each allegation, admit, deny. And honestly, the complaint and answer are rarely looked at once they're filed. They are just the pleadings that get the case started on behalf of the plaintiff and then on behalf of the defendant. Sometimes the defendant includes a counterclaim with the answer, and it's not done as a matter of course, and it's not always necessary. Some of the reasons you might want to do what we call a counterclaim, which is the defendant also filing for divorce, is if the plaintiff didn't address alimony or spousal support, and you want to make sure that issue is before the court. If you have some separate property, or if you have any concerns that the plaintiff might try to dismiss, so that the case is still would be before the court on your counterclaim. Again, these are mostly technical issues that we discuss with you throughout the process, and especially at the beginning of the process, if that's right for you. A new court rule that just went into effect this year, 2020, says that 45 days after the defendant, not 45, excuse me, 28 days after the defendant files the answer to the complaint, the parties have to exchange a verified financial information form. And this was enacted to start the flow of financial information automatically, that you didn't have to wait to issue extensive discovery interrogatories, document requests, that as a matter of course in the state of Michigan, 28 days after an answer, you have to exchange tax returns, lists of your assets, certain statements, financial statements, bank statements, credit card statements, so that there are these minimal disclosures right at the beginning of the case. That being said, that doesn't prevent us from entering into additional discovery, and that additional discovery can be through interrogatories, which are questions we send to the other side to answer under oath, under penalty of perjury. We can take depositions. We can ask for document requests. And of course, we can also seek information from third parties. We don't always want to rely on the other spouse, the other side, to be giving us all the information. Sometimes there's a lack of trust and we're concerned that all the assets aren't being disclosed. So we can issue subpoenas to banks, to other financial institutions, to businesses, to credit cards, and to employers, and the like. So the discovery is the period of time where we basically gather all the necessary information to proceed to settlement. And during this period and in general, we're going to address separate versus marital property. Separate property is property that you owned prior to the marriage, that you didn't commingle, property that comes to you by reason of gift or inheritance during the marriage that you similarly keep separate and don't commingle, versus marital property, which is defined as property that comes to the parties by reason of the marriage. And what's important to know about marital property is it's not just limited to property that's in joint names. A certain property, for example, can never be in joint names, like an IRA or a 401k is always just in one person's name. Nevertheless, a 401k earned during the marriage is marital property to be divided as part of a divorce. And there are also ways that separate property can be invaded, even if it is gifted, inherited, and kept separate. And the two ways that separate property can be invaded are if the other party contributed to the acquisition, appreciation, or accumulation, or secondly, if there's insufficient marital property to otherwise support the parties. This is very much case by case. This is something that we discussed last week or the week before in our first webinar on prenups, which is a reason sometimes to enter into a prenuptial agreement to try and protect separate property. But even without a prenuptial agreement, there are many arguments and many ways to protect your separate property and to keep separate property from being included in the division of marital assets. But even though it's not divided, it still needs to be addressed in the final settlement and awarded to the party who claims the property as his or her separate property.
Thank you, Susan. Jen, will you continue with the overview of the divorce process?
Sure will. So once we've moved through the discovery phase and we have all the information gathered that we hope that we can gather, we need to move towards settlement. So you can always reach a settlement just between the parties and their attorneys. And quite honestly, that's usually the best way to go, because necessarily litigation is not really the best format to handle family issues or issues regarding kids, but it's the method that we have right now. So what some counties have done, especially Oakland County and different counties around our area, is that before we get to the trial phase, if the parties can't reach an agreement on their own, is that they'll require the parties to go to mediation. Like, for example, Oakland County, once you have a status conference several days into after filing the complaint for divorce, the court will call the attorneys in and sometimes the parties in as well, make sure we're moving forward on discovery and exchanging of information. And they'll want the parties to select a mutual mediator that will help the parties move towards a resolution. If we can't agree on a mediator, the court will actually appoint one. A mediator, generally speaking, is another attorney in the area that's familiar with family law, that knows the judges and understands the process and how family law is going to work in your particular area. And their role is as a neutral person to try and sit down with both parties and their counsels and see if they can help guide them towards a resolution. We all recognize that while trials and arbitration is sometimes necessary, it's not the best way to go in the vast majority of cases in family law. Trials and arbitration are very expensive. They cost a lot of money for preparation. Right now, in the era of COVID, they're taking even longer with requiring of Zoom hearings. It takes a little bit longer to exchange documents, to show exhibits in that format, and it's just taking a little bit longer. So it's expensive. It takes a long time. Even pre-COVID, it took a long time. You don't necessarily get 2 or 3 or even 5 days in a row to sit in front of a judge. You might get a day or two here, another half day a month later, another day or two the following month. So it can take a really long time. And perhaps the most difficult thing about trials for parties in divorce cases is that it's extremely emotionally draining. You have to put it all out there to try and prove your case, to try and show how the other spouse didn't do what they were supposed to do, or weren't necessarily a good person in the marriage, and that's why you want the divorce. So especially when there's kids involved, proceeding with a trial regarding parenting time and custody can make it nearly impossible to try and co-parent after that based on what you have to go through in the trial process. So we really do encourage people as much as they can to try and work out the resolution on their own with their attorneys, and if not, to work through the mediation process so they can kind of reach that resolution on their own. Also, working through the mediation process is parties have their own ability to kind of set their own destiny and set their own rules and expectations for moving forward. So that's another big benefit of doing mediation. There's two different ways of doing mediation that are commonly followed in our area. Oakland County follows what's more called the shuttle diplomacy. And if need be, the mediator will go back and forth between rooms or between Zoom rooms to talk to the parties and try and see if they can, on their own, move the parties towards a mutual agreement. There's also collaborative mediation, which is more of the whole group gets together, the attorneys, the parties, and the mediator to try and problem solve and see how they can work forward in a creative way to have a global resolution regarding everything. If mediation does not work, then in some cases there is a requirement to go forward for trial and arbitration. And I'll also note that in Michigan, there is a divorce or domestic violence screening in order to do mediation. The courts want to make sure that in order to proceed with mediation, one party or the other is not feeling that they don't have an equal bargaining position or they're fearful for their safety. So if that's the case, if the domestic violence is a concern or an issue in a divorce case, then mediation may not be appropriate, and it may be more appropriate to proceed to a trial or arbitration. So the difference between a trial and an arbitration process is the trial is in front of the judge. There's never a jury in a family law case. It would only go to the judge. It's a very formal process where you would present witnesses, you would present exhibits, you would present testimony, and to prove your case. Arbitration is with a neutral individual, usually an attorney, or it is an attorney, who will sit down, and it's a little bit more of an informal process, although you still have to follow court rules and present evidence and testimony and exhibits. But it's in, generally speaking, the attorney's office. It might be a little bit more low key. People may want to choose arbitration if they have particularly sensitive issues in their marriage and their divorce case that they don't want on the public record or to be talked about on the open in a courtroom. Or if they have concerns, if their judge has an extremely long docket and they can't get a date quick enough to get in front of their judge and they want to try and resolve things. So those are some reasons why you might want to go to arbitration. You do have the ability, once a trial or an arbitration is completed, once the judge or the arbitrator makes their opinion or their award, to appeal that. One thing for arbitration is that you have a more limited ability to appeal that than as opposed to if you went to a trial in front of the judge. But again, that's extremely costly, expensive, and time consuming. And you want to try and make sure you get everything done the first time around. Following the trial and arbitration and an entry of the judgment of divorce, there are occasions where you may have to go back in front of the judge or even an arbitrator. We try and resolve those as much as possible at that process, and also make sure that the judgment of divorce is as clear and concise as possible so the intent is known. But sometimes you just can't avoid post-judgment matters. For example, we can talk about this again in our next session, but if a parent needs to move to a different state, or if there's concerns about the kids and you need to change their schooling, or sometimes if maybe assets were found after the judgment was entered, then it needs to be reopened. But for the most part, we try and get as much done as we can in that first go around. So that's a little bit about that process.
Thank you, Jen. We have to go to mediation to settle.
Oh, there's always the possibility to settle on your own. It's not, out of the world idea for someone to come to us and say, hey, my spouse and I have been actually talking about this for a while. We know exactly what we want. We just want some help drafting up the judgment. We can do that. You don't have to go to mediation. And also, we always try first to work it out with the other side before that step. So, of course, you can definitely resolve that before. Mediation is not required. It's only required if you can't reach that agreement on your own. it's kind of it's an in-between phase between reaching an agreement on your own, or if you have to go to trial. So you can definitely settle it on your own.
Thank you, Jen. And settlement agreement.
So the divorce process generally ends, if absent reconciliation, with a settlement agreement and a judgment. Every divorce has to have a judgment of divorce. That's the document that the judge signs and that actually divorces you and your spouse and ends your marriage. And a judgment can be extremely detailed, or it can be very bare bones, what we often call a wraparound judgment. And most of the details can be in a settlement agreement. And why we like to do that is because the settlement agreement doesn't get filed with the court and therefore does not become a public document, part of the public record. And in today's world, in some counties like Oakland County, for example, you can get online and for $1 a page, you can order anything. Other counties, it's a little more difficult and you have to go into the county. And obviously now with COVID, that's more difficult, but you have to go to the clerk and order it in person. But either way, most people would like to keep those details of their life personal. So we generally do a separate settlement agreement. For that reason. Certain things, however, must be in the judgment of divorce. And those things that must be in the judgment are provisions related to custody and parenting time. And again, we're going to get into that in much more detail in our next webinar, but you have to indicate whether it's joint legal or sole legal, joint physical, sole physical, and what the parenting time schedule is. You would also need to include the child support. Who's paying child support, the amount, something we'll also talk about next time. And then the rest, the division of assets, this is the part that we often like to keep private. Not always. Sometimes it's vague enough that it doesn't really matter if it's in the judgment. Sometimes it's wife's getting all her accounts, husband's getting all his, that it's fine for it to be in a judgment of divorce. But often, especially in a lengthier marriage or more complex estate, there's going to be a lot of details about account numbers and assets and business interests. So we like to keep that as private as possible, but in the actual settlement agreement, there's going to be a lot of those details. And similarly, the division of liabilities. If someone's taking the house, they're taking the mortgage, a leased car, credit card, all sorts of lists of your liabilities and who's responsible for what. A very important issue that gets addressed is alimony or spousal support. And of course, that's the payment of support from one spouse to the other for his or her support. Folks often, ask us about that. Does alimony still exist? And the answer is absolutely. Alimony, we call it spousal support in Michigan, but it is alive and well and still exists. There is not one formula as to how you calculate alimony, although we do have a computer program that we run that many other lawyers and judges run as a starting point, but it is not binding. Alimony is based on equitable factors, as I indicated earlier: age of the parties, health of the parties, length of the marriage, ability to pay, certain rules of thumb, depending third, a half of the length of the marriage, but there is no one formula for alimony. What is important is it can be modifiable or non-modifiable. Modifiable means just that over time, if there's good cause, change of circumstance, the court can change it. You lose your job, you have a health issue, you get a new job, you earn more, things like that. You can go to court, file a motion and say, I can't afford to pay this anymore, or I lost my job, my spouse was paying me and I need more money. And the court can consider that. If it's non-modifiable, you're done. If you've decided in your judgment of divorce, one party's paying the other party a certain amount for a certain length of time, non-modifiable, that's it. And we put in language that regardless of what happens, be it act of God or something, pandemic, something seen or unseen, foreseen, not foreseen, it doesn't matter. You can't change it. Important about non-modifiable alimony is you have to agree. A court cannot, if you go to trial, as that Jen just explained, a court can't order it to be non-modifiable. That's only something that two parties can agree. And of all the things, spousal support is very fact-specific, case-specific. So that's something, while we in this overview can't stress enough, that we're kind of giving you this overview, but whether or not in your case, what you would be awarded or you would have to pay spousal support is very fact-specific. When there is spousal support or child support, there's generally security that can be in the form of life insurance, depending, it can be liens, it can be all different things. That's something that we like to address and include in our settlement agreements and judgments. And then there are certain statutory provisions required by statute that except as set forth in the agreement, you're waiving the right to your spouse's pension and retirement plans. You're waiving your right to your spouse's insurance plans. There are just certain provisions that we have to include. And when we settle, we generally require and ask for and receive a full disclosure and waiver and releases. And what that refers to, we want your spouse in this document to certify and state, basically under oath, that he or she has disclosed all of his or her assets. And we want the ability to come back if later down the road we learn that something wasn't disclosed and something was included. And this is something that we can address much more fully if we settle versus if we go to trial. Certainly if we go to trial and your spouse lies, we're able to come back and bring that to the court's attention, but we have a much shorter time frame. You basically have a year after trial if you find undisclosed assets to come back to the court. If we settle, we can build into our contract a longer time frame to address a advertent or inadvertent failure to include all the assets. We may also include waivers and releases, that this is it. You're never going to, everything up till now, you've waived. You're not going to sue me. We're done. This settlement resolves everything that we knew or could have known or should have known, that any claims we have against each other up until this point in time. And this is something that you're not going to get if you go to trial, but that you will get if you settle. And it's something that we want to talk about, because maybe you do have claims against your spouse. If there was domestic violence, you might have a tort claim. There may be reasons that you don't want to sign a waiver or release. These are things we will discuss. And then in most judgments, we address attorney fees, who's paying for them. And this also is case by case. Sometimes they come out of the marital estate and each party gets the same amount. Sometimes each party pays his or her own fees. Sometimes one party pays the other attorney fees. So that's something that we're also going to address in the settlement agreement and the judgment.
Thank you, Susan. Jen, will you address answers to commonly asked questions?
Sure. So the first one is, can we use one lawyer? And the simple answer to that is nope, you cannot use one lawyer. You don't necessarily have to have two lawyers involved in the case. If one party hires a lawyer, that lawyer can represent that individual and then negotiate with the other side. But one lawyer cannot represent two people in a divorce case. We just cannot do it. It's a conflict of interest. So you don't need two lawyers, but one lawyer can only represent one party. That's the simple answer on that one. You want me to take the next one, or are we going to have Susan take that one?
Susan, you take the next one. Do I have to live with my spouse during the divorce?
Again, not a one-size-fits-all answer. Most of our clients do end up living together during the divorce. It's not always a happy time, but it generally does happen for a variety of reasons. We haven't divided up the estate yet. You may not know how much money you have to buy a new house or to figure out where you're going to live. We haven't decided who's keeping the house. And the most important or common reason why folks remain together is because of the kids, because we haven't decided the parenting time schedule yet. And there could be an advantage if one party moves out before the parenting time is decided. But what I will say, a common question we get, do I lose the rights to my house if I move in? Absolutely not. You do not have to stay in your house. You don't lose property rights by leaving. There's no such thing as abandonment of your spouse. We get asked that question. So in that sense, you're certainly free to move out. We just have to address certain issues, expenses, who's staying in the house, who's paying the bills. So again, not a one size fits all answer, but certainly when you say, do I have to, the answer is no. And of course, there would be reasons why we want to get someone out of the house, such as domestic violence. And that would be an important reason for you not to be living with your spouse during the divorce. Jen, next one.
So, will my divorce end up looking like my friends or my sisters or my brothers or my neighbors? Again, the simple answer to that one is nope, it will not. While we have to follow the same law and the same guiding principles, no two divorces are alike. They're always different because we have different facts. We have different individuals that are getting divorced and different personalities. Every judge is a little bit different. You have different personalities with the lawyers. So there's always something a little bit different from one divorce to the next. There's no cookie cutter way to finalize a marriage and to move forward into the next chapter of life. So while going through a divorce case, most people are going to get a significant amount of advice and suggestions and, well, what about if, from their friends and their sisters and their neighbor across the street. But again, it's important to remember that while these people can really offer a lot of emotional support and help guide you through the process, the person that you really want to talk to about the process and what is going to happen in your case is your lawyer. So good amount of emotional support from your friends and your colleagues and your neighbors, but there's no guarantee to say that your divorce is going to look anything like theirs because they just don't work that way, unfortunately.
Next, do the years we lived together before marriage count? And simple answer is no. Michigan does not recognize common law marriage. It was abolished many moons ago. That being said, I can't say that in my years of practice, we haven't tried to bring that in or as necessary as one of the equitable factors. And certainly it's something that can come up and as if we can use it to our advantage, we certainly will. But as a matter of law, you're married from the day you say I do, and you're divorced on the day the judgment is signed.
And Jen, the last one.
Last one's me. So what happens if my spouse does not disclose all of the assets? Well, we do everything that we can to try and discern what the assets are during the process, but it does occasionally happen that assets are hidden either, oops, I forgot about that account from when I was 12 years old, or purposely trying to hide assets in some remote island somewhere. So if that does happen and it's discovered after the judgment is entered, the process would be to file one of those post-judgment motions that we talked about and inform the court that there were assets that were not disclosed during the process and reopen the property provision. That's really the only time that we can reopen a property matter once a judgment has been entered. But you do have recourse. It can be expensive to find those things, but again, if they are disclosed, if they're undisclosed, then you find them after the judgment is entered. We just bring it up to the court and let them know, and then proceed with that. And either that party, if it's inadvertent, the court might say, okay, that asset is divided 50-50, or if it was a purposeful failure to disclose, then that asset can actually be awarded to the other spouse 100%. So it just depends on the circumstances. Again, no two cases are identical.
Thank you, Jen. So open up a Q&A for any attendee questions. If you would like to put them in the Q&A, we have received a few so far. So I will get started. Susan, we'll just go right back to you. How much is my divorce going to cost me?
And at the risk of sounding like a broken record, no two cases are alike. At Jaffe, we charge by the hour. We have various hourly rates depending on our experience and length of time practicing. And as I say, in every new client meeting. I've done divorces for $2,000. I've done divorces for $200,000. And obviously the 200 is rare and not often. And that was, full-blown trial, 12 days appeals and everything in between. At Jaffe, our goal is to do it as expeditiously and efficiently and cost effective as possible. No case has to be my career case, because the parties do that on their own. If you come to us, we've settled, this is what we want to do, help us, my pleasure. And Jen, Christy, and I, the rest of our team, Michelle and Annette, who aren't on today, we are more than happy to work with you and hope that you will be one on the low end and not one on the high end. But I can never guarantee, without knowing the specifics of your case or knowing who opposing counsel is and all those things, it's even hard to give a ballpark until we meet and start getting into the weeds, as we say.
Thank you, Susan. Jen, we did touch on this a little bit earlier, but we have a question. How long does the divorce process really take?
Well, the fastest we can get done with the divorce case is at 61 days from the date of filing of the complaint to the date that the judge will stamp your divorce and you're all done with the process. But how long it can take in Michigan, the courts have said that they want it done within a year. So if you can't resolve it, then the judge will want you to have that judgment of divorce ready to go before that 1 year mark from when you filed your complaint for divorce. Or have started the trial process or the arbitration process. So if you go into arbitration, it can last a little bit longer than that, but you need to have some type of resolution in front of the judge within that 1 year mark. So there is an end in sight. We just, again, don't know exactly.
Thank you, Jen. We do have another one. Susan, does the judge have to approve our settlement?
Yes and no. In terms of the settlement, whatever you resolve with your children, the judge has to make an overall finding that it's in the best interest. And our experience, though, there are a handful of judges who really take that seriously and ask questions and make both parties appear. And some even also will go through the property settlement and the alimony, especially if you're waiving support or agreeing to non-modifiable, and just make sure the parties are doing it knowingly and without duress or coercion. But overall, the judge really just rubber stamps. Especially if both sides are represented by counsel, it would be very, very, very rare for the court not to, quote, approve the settlement.
Thank you, Susan. And we do have one last question. Jen, what if I am afraid of my spouse's reaction?
Perhaps the most important thing that we do as family law attorneys is make sure that people are safe when we're moving through this process. So if there is a concern about physical safety, we want to make sure that we can do some safety planning around the time of filing the complaint for divorce and then throughout the process. There are the ability to get personal protection orders through the court if there has been a history of physical violence. We can also make sure that we take safety precautions before the complaint is filed. There are some attorneys out there that kind of monitor divorce filings and notify the other side that, hey, your spouse has filed a complaint for divorce. Did you know that? Why don't you give me a call? So we want to make sure that people are in a good, safe place before we do file that complaint for divorce. There are several domestic violence shelters around that can provide some additional safety planning, but it is a concern if you are worried about a physical or some other type of dangerous response from your spouse, to talk to your attorney about that. They can work with you on that, but they need to know the details and they need to have an understanding of what the concern might be. So definitely talk to your attorney. We can do safety planning and we can make sure that everything is in place that we have power over, to control over, to make sure that an individual is safe. Again, through those ex parte orders or for personal protection orders, or for some simple safety planning on getting out of town for the weekend when the complaint is filed and served. So there are things that we can do to move forward and still proceed with the divorce case.
Thank you, Jen. Thank you, everyone, for joining us today. If you did not ask a question, but you do have a specific question, you are more than welcome to reach out to us directly via our contact information provided. You will also be provided a copy of today's presentation, and a recording of the webinar will be available on demand within a few days at jaffelaw.com. You will also receive a survey for your feedback, and we would really appreciate if you would fill that out. And also, in case you are interested, we do have a third family law webinar upcoming on family law matters involving children. It will be on November 19th. You can find out more information on that webinar by visiting www.jaffelaw.com/webinars. Thank you again for attending, and we hope you have a great day.
Thank you.
Thanks.